Viewers, what separates a democracy from a dictatorship? In dictatorships, power flows from the center completely unchallenged. The courts are powerless, the opposition is neutered, parliament is an ornamental rubber stamp to legislate on decisions taken somewhere else. But democracies are different. In the best ones, like India, all institutions of the state like the executive, parliament, judiciary are independent of each other. The state has self-correcting mechanisms that keep the organs of governance in check and most importantly ensure these vital organs work transparently and are subjected to accountability. This system works when all organs of the state are equally accountable. In our system, to put it simply, the executive and parliament serve at the pleasure of the people. No matter how much power they concentrate in their own hands, eventually, if the people aren't happy, they will be voted out. And that happens every 5 years when we hold the greatest festival on earth, which is the festival of elections, the dance of democracy. But the judiciary in India is placed at a slightly different pedestal from the other two organs. It is accountable to the Constitution. It is designed to be independent so that it can act as a check on the legislature and executive. But there's a growing perception, and it is being echoed by people like the Vice President of this country, that over the years, the judiciary has misread autonomy or institutional independence to mean immunity. The process of appointing and elevating judges lacks transparency. There's a closed collegium system. Many judges, some of them who've been chief justices, have said the collegium system should make way for another more inclusive system, more transparent system. There's no real robustness to the mechanism for judicial misconduct. Contempt laws put it beyond criticism. Even the media, by and large, exercises caution in reporting on the judiciary. Perhaps that's one of the reasons why other news channels tonight are not doing the most obvious story, the most consequential story. Viewers, this sort of, I don't know what to call it. It's not skepticism. It's much more than that. This sort of lack of conviction or courage has become true of late. When a cash haul was discovered at the home of the judge of the Delhi High Court, no media beyond 3 or 4 or 5 days carried this story. Today it's buried. 2 days ago was 1 month since that cash was discovered. Is anyone talking about it? Do you see it on the front pages of your newspaper? This incident and a few judgments of recent has caused many people, including the Vice President, to criticize the judiciary. Listen into what the Vice President has said once again. We had done a bit of this yesterday, but listen in full.
There is a directive to the President by a recent judgment. Where are we heading? What is happening in the country? We have to be extremely sensitive. It is not a question of someone filing a review or not. We never bargained for democracy for this day. President being called upon to decide in a time-bound manner. Judges who will legislate, who will perform executive functions, who will act as super parliament, and absolutely have no accountability because law of the land does not apply to them. Article 142. Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7.
Viewers, here are a few verdicts that have triggered the criticism. The first one is what Jagdeep Dhankhar, the Vice President, was referring to. He said the timeline for President has been set now, pretty much by the Supreme Court. In fact, the Supreme Court set 3 months timeline for the President to clear bills, following which the states can issue mandamus. Yes, the states can seek a directive against the President post-deadline. What is the criticism? The criticism is a violation of Article 361 that protects President's office. The defense is that time limit is needed to safeguard will of the people, that the will of the people leads to a assembly passing a particular bill. That bill is in the interests of those who voted for that particular party or that grouping to ensure this legislation is passed. So this is important. Now let's look at another case, the cash haul case. What's the status? As of now, there's an in-house panel that has been appointed to probe into this cash haul from a High Court judge's home. The criticism is there has been no FIR. There's obvious conflict of interest because it is a panel, in-house panel of judges examining alleged impropriety committed by another brother judge. So there is autonomy without accountability. The defense is inquiries as per procedures that have been well accepted and laid down. And that judges have to be given protection, because what if tomorrow certain victims or who think they are victims of a bad order decide to turn around and impute motives on the judge or make claims, and cases are booked, the judges will be harassed. But the Vice President has made certain comments, but he's been severely criticized, viewers. Listen it.
The President acts on the aid and advice of the Council of Ministers. The Governor of a state acts on the aid and advice of the Council of Ministers in the state. अपने व्यक्तिगत अनुसार कुछ नहीं करती. प्रेसिडेंट एक्ट्स ऑन द एड एंड एडवाइस ऑफ द काउंसिल ऑफ मिनिस्टर्स. वो बात सरकार, केंद्र सरकार पे जाती है, केंद्र सरकार के काउंसिल ऑफ मिनिस्टर्स पे जाती है. वो एडवाइस करते हैं प्रेसिडेंट को कि क्या करना है. ये प्रेसिडेंट का व्यक्तिगत हक नहीं है. ये धनखड़ जी को मालूम होना चाहिए. उन्होंने कहा कि आप प्रेसिडेंट की पावर को कैसे कंट्रोल कर सकते हो. भाई कौन कर रहा है प्रेसिडेंट की पावर को कंट्रोल?
राजनीति के एक ऐसे कालखंड में है जहां हमें इन चीज़ों पे बहुत संवेदना से सोचने की ज़रूरत है. एग्जीक्यूटिव हो, लेजिस्लेचर हो, जुडिशियरी हो, यहाँ तक कि मीडिया भी हो. अगर इसमें एक फाइन बैलेंस नहीं रहा तो मेरा मानना है कि किसी को ओवर रीच से बचना चाहिए.
सुप्रीम कोर्ट जो है वो फाइनल है. सुप्रीम कोर्ट को हम मानते हैं. अब ये नहीं कह सकते कि सुप्रीम कोर्ट जब हमारे हित की बात करेगा तब हम स्वीकार करेंगे, और जो हमारे खिलाफ जाएगा तो हम उसको नकार देंगे. ये नहीं आप कह सकते हैं. सुप्रीम कोर्ट का अगर फैसला है आपके हित में हो या आपके अहित में हो, उस फैसले को मानना है. हम लोग सुप्रीम कोर्ट में विश्वास रखते हैं, हम सुप्रीम कोर्ट में मानते हैं.
The irony is, viewers, that a large number of these lawyers turned politicians, politicians turned lawyers, what have you, they belong to political parties that just a few years ago in Parliament voted a bill that would have brought about transparency and judicial accountability. But it was the Supreme Court that sat on judgment on that particular bill and struck it down, said it's illegal. What do you do in such a case when the will of Parliament and as expressed through Parliament is struck down by the judiciary in a case that applies to it? So, having said this, is the Vice President's criticism justified? Has the judiciary taken independence to mean autonomy from accountability? We're joined by Mr. Mahesh Jethmalani, senior lawyer of the Supreme Court. Needs no introduction. It's an important and consequential matter, Mr. Jethmalani. The reason why the Vice President is being criticized, and that's what I gather from my notes and from my little research, is primarily two. The first one is that the VP's comments on the Supreme Court strayed far beyond the propriety demanded of those who hold largely ceremonial offices. It's not really about the fact that as an individual he can't be critical. It's just that he doesn't have the authority, so to speak. How do you react to this?
Well, I don't think he reacted qua his ceremonial position. If he had done that, then perhaps you could have said that it was a question of impropriety. This was at a lecture which he gave, right, where he responded to certain events, particularly those which affected the powers of the president, right? The extent and scope of the powers of the president when, considering whether to assent a bill reserved for his consideration by the governor of a given state. So in that capacity, right, if he has a constitutional view, it's a view, right? He's also a distinguished lawyer before he became VP and, Speaker of the Rajya Sabha, the Chairman of the Rajya Sabha. But in that capacity, so long as he's not exercising that ceremonial function and restricting himself to what the rigors of that ceremonial position require him to be confined to, right? If he is giving it outside and reacting to what he considers to be a patently flawed constitutional view, and in this case, I'll tell you what it was and why he perhaps was fully justified, right? It is under Article 145(3) of the Constitution, Rahul. If there's any question pertaining to question of law pertaining to the interpretation of the Constitution, it must be decided by a 5-judge bench. Now, this matter came directly to the Supreme Court, right, under an Article 32 petition, I believe, right, if I mistake not. So, when it came by way of an Article 32 petition, the court, when it realized that it was being asked to opine on or decide on a question of requiring the interpretation of a constitutional provision, it should have referred the matter to be placed before a constitutional bench, because under Article 145(3) it requires consideration by a 5-judge bench. That's all he said. So in effect, what he was saying was there's a very fundamental flaw here, which that bench should have noticed, and unfortunately, I don't think any of the lawyers who were present pointed it out, that if you're going to go into this question, right, and by the way, the scope of the presidential powers, right, in that Article 201 situation where the governor has reserved it for his assent, right, was not even before the court. Really speaking, what they were talking about the 10 bills which the governor had, struck down, had actually withheld his assent to, or whatever he did with those bills. It was the governor's conduct that was there, right? It wasn't it wasn't even a question of the president's. The president's was a de futuro action. It was still to take place. So why did you opine in it? Nobody asked you for it.
Okay, so the second criticism broadly is this, that even as a governor, he played the part of really the political agent of the center, and it appears once again he's doing the same, because his criticisms sort of coincide with reversals that the government thinks it is suffering or in court.
Look, there are some people who are irrepressible, right? Justice, Vice President Dhankhar has, he's prone to be outspoken, right? But so long as he doesn't exceed it when performing his ceremonial functions, right, I think it's fully justified. I mean, it may, and that's a question of perception, Rahul. You may be right, and people may be right that he's being perceived as somebody who's becoming a hatchet man for the government whenever it is so required. That may be a perception, but so long as he's performing that function within bounds which he can exercise them, notwithstanding his other ceremonial function, I don't think there's anything anybody can. I think people are just upset because what he says is pretty effective both in style and in content. So I think it sort of rubs people the wrong way that he is so outspoken and normally correct.
Okay, so very quickly, when you say normally correct, he said that the judges have absolutely no accountability because the law of the land does not apply to them. Is he correct here?
Well, you see, if you look at recent events, Rahul, right, the Supreme Court in particular, right, has become an opaque institution right now, and many bar associations are already upset by this, right? For instance, when there's a judge as you saw in the Yashwant Verma case, right? The remedy is to have an indoor, closed door meeting between the collegium and just transfer him out to another court, right? And public are saying, but look, there's huge amounts of cash caught within the precincts of his premises, right? Why should he get this preferential treatment? I mean, there's no law which prescribes that judges are above this kind of thing. If they're corrupt, they have to be brought to book in the normal manner. Okay, because they are judges and disgruntled litigants can frequently, just because an order goes against them, right, take out vengeance, they must be given protection. And that's the inquiry. So they're having the inquiry right now. I regret to say the inquiry is taking a little too long, but that's it. I mean, maybe it does require that. Maybe it does require a long inquiry. That's not for us to say.
Okay, we leave it at this, Mr. Jethmalani. Thank you very much for taking a view and setting up this debate.
Thank you, Rahul.
Well, let's take this out to the wider panel that joins us this evening. Aman Lekhi, senior advocate and former ASG. Let me come straight to you. You need no introductions. A man of great experience, learning. Now, Aman Lekhi, a lot of criticism is directed against the Vice President. Is the problem with the substance? What is the problem with exactly? Because a lot of what he says, he has weighed in with some context. And at least prima facie on the readings of the developments of the last few years, etc., it doesn't sound unreasonable, his critique.
Well, Rahul, I'm sorry. I mean, on this point, I'll disagree with you.
Sure.
I have objections both to the manner of expression and the content of what it contains. One, as far as the manner is concerned, I'm very against sanctifying acting some element of divinity to a constitutional position. And the manner in which it is said, oh, the president, how can you do it to the president? Question is, you can do anything to a president if the president acts in a manner which is ultra vires or it's a mala fide. The law is clear. You refer to 361, where you said in the beginning, 361 does not in any way immune the president from scrutiny if the allegation is mala fide or ultra vires, and that is something for the court to decide. One. Two. Insofar as the content is concerned, I feel, I heard Mahesh and he referred, both of them are referring to 145. Now, 145 also is misconceived because it's not any question of interpretation. It's a question of substantial question of law, of interpretation. Now, substantial is in degree, it's different. That is, if the principles are generally decided, the court can, even a bench of less than 5 can look into this particular matter, and this is how it proceeded in this particular case. So 145 is not relevant. Now, what is the reason why this is said by the Supreme Court? And there has to be some clarity because you can't just attack an institution in the air as it happened. There were bills. The bills are not being passed. The bills, assent was not given to the bills. The law till this judgment came was that as far as the governor is concerned, there can be no judicial review of his discretion. So what the court found was a period of time, 4 to 5 years, was pending. Many bills are pending. So the assumption that the constitutional holder will actually act in a manner which is appropriate was found to be misconceived. So what the court did was, because the assumption is everything has to be done in a reasonable period of time, fixed a timeline. Now, that's a timeline is implicit both in 200 and 201 and is implicit in the principles of law. And fixing a timeline for deciding a matter is not something unreasonable nor in excess of the boundaries which are set. Having done that, the court said, exercise power under 142. 142 followed the interpretation which the court gave of 200 and 201 and was consequential to it. Now, if the court, without looking at 200 and 201, that is dealing with the president and the governor, had of its own gone into 142, then the criticism would have been justified. But in the circumstance of the case, I feel, this is my opinion, of course you will have a different, in the circumstance of the case, it was warranted because the court said, as the withholding was wrong, we are now acting. It is not as if they did it in a manner which is without authority or necessity. In the circumstances, it was warranted because the word in 142 is interest of justice and the facts of the case. So everything it is done is within the constitutional bounds. And when it is in constitutional bound, mainly because of disagreement with the outcome, I think criticism only for that reason is unnecessary.
No, hang on. So, just a minute, Mr. Lekhi. Let me just break this down for our viewers because yours response was slightly legalistic. So, let me say, give you a very easy to digest definition of what really transpired. The court the attention of the court was drawn to a problem, a standoff where a governor in Tamil Nadu was sitting on bills that had been passed, 10 of them, that had been passed by the state legislature, and he had been sitting on them for an inordinately long period of time. 8 of those bills, you have a situation where 8 of those bills were not referred to. 2 of them were sent up to the president. 8 he returns to the state assembly. The state assembly sends them back because that's the procedure, and he refers all of them basically to the president, where the president also then is not showing great alacrity in passing these bills. So the worry is that the will of the people expressed through the state assembly is being blocked. Those 10 bills were important bills, and how can you have a governor, unelected authority, block the will of the people? That's the real nub of this. Now, in deciding this matter, when the Supreme Court was brought into it, it extends this deadline of when you can settle these bills and when it has to be signed and disposed of by the governor to also the president's office, which was not actually referred. The reason it was done is because it would have completed the chain of operation. Correct me if I'm wrong, Mr. Lekhi.
Yes.
Right.
Yes.
Now, the point is, no one has a problem with anyone in any way expediting the business of lawmaking, because that is what assemblies and various functionaries who are elected and come to those assemblies do. Legislators do, they legislate. So that has to be done. No quibbles with that. But when it comes to questioning holy of holies, then we also have a small problem here, because it is assumed that the judiciary is above question. Now, many people are saying, legitimately, Mr. Lekhi, that maybe this matter, given the sensitivities involved, the checks, the balance of power, should have been decided by a larger bench. But that doesn't happen. What do? You don't criticize, you don't ask, you sit quiet. What happens in that case, Mr. Lekhi?
Well, see, at the outset, let me say, it's not as if the Supreme Court is immune from criticism. I am not saying Supreme Court is not accountable. You had actually also mentioned, insofar as the method of appointment of judges is concerned, yes, it requires change, it requires modification, and there has to be an institution, a method which is in place, which addresses the concern which are legitimately arising. Now, the question is, there's a problem at some place, doesn't necessarily mean that because there's problem somewhere, we imagine problems elsewhere.
No, I'm not saying that. I just asked you in a specific case. In this matter,
yes,
many people are saying that a larger bench of the Supreme Court should have sat on this issue. Only 2 judges did, and that many people think is not the way they should have been handled. It's a constitutional issue after all. It has implications.
Rahul, every matter in the Supreme Court has a question relating to interpretation of the Constitution. In this particular case, the Attorney General was also appearing in this particular matter. It's not as if this was in the absence of the Attorney General. The Attorney General is the topmost law officer of the Government of India. So the Government of India was represented through the Attorney General, and the issue which was there was before the court as was contested by the Attorney General. And if that in that situation, the Supreme Court passed the order on the basis of submissions which were made. Now, after the submissions are made and that this order is passed, the Vice President, my problem is not, you can critique the judgment, and I have a view which supports it. There can be another view, legitimate, which says that the judgment is wrong. I'm not on that issue at all.
Yeah.
What I'm saying is, the manner in which it is spoken, one, you can't say the President. What are you saying?
That stands. Now, hang on. Let me open this up. Mr. Amitabh Sinha, I understand. You're saying that, oh, the president is not above question. What if the president acts in a mala fide manner? What if judges do? And we have an example, Mr. Amitabh Sinha, where there is a perception that a Delhi High Court judge has not been treated with the rigor that an ordinary Indian citizen would have been had money had been recovered, unaccounted cash from his home, in circumstances that unfolded in similar situations. So, what do you do in that context? Should you keep silent? Should you not ask a question? Should you let bygones be bygones? Should you paper it over, look the other way? Because you see, some institutions, their autonomy, etc., has to be protected.
Thank you, Rahul. This this issue, this question is really very important and sensitive for the Indian democracy. Let me accept this. And thank you very much that you have taken this issue in a very like seasoned manner. I am really appreciative of your approach. Now I am coming to the point. See, Indian Constitution has arranged a very beautiful arrangement for the balance of power. I mean, all three wings of the Indian democracy, they have been given proper validity and I am just talking that your viewers can understand in a very legal, clear and simple manner, not legal complicated manner. I am just trying to tell you that the balance of power is there in the Constitution through Article 121, 122, and so these things in 121 Supreme Court has been given this seclusion, and Supreme Court has been given the sanctity, and in 122 the executive and the legislative. So this is very clear and very beautiful arrangement. Now comes 122. See, in 122 the important thing that the legislative arrangement is not a part of the judicial purview. This is very clear in Indian Constitution. Now, what Mr. Vice President has referred to 142. See, 142 is already there. I am not going on that particular thing, but before that I would like to highlight 124. Article 124 is very clear about the appointment of the judges. And who is the appointing authority? The President of India.
Yes.
So, President of India is appointing authority. So, the judges are basically being appointed by the President of India. So, judges cannot give dictum and instruction to the employer. So, this is a very common man's understanding.
Common man's understanding.
The seal of the President.
Senior advocate of the Supreme Court, Amitabh Sinha, says, look, at the end of the day, look at the Constitution. The Constitution has all the answers. Use common sense. We don't need to get caught up in propriety, etc., etc. Okay, that's an important point.
See,
let's take it one by one.
I am just trying to explain. Yeah. I am just trying to tell your viewers that with the seal of the President of India, the appointment of the Supreme Court judges, High Court judges, and the Chief Justice of India is done. So, in that perspective, if the appointed person, the employee, gives the dictum to the employer, it is highly improper.
It is improper, he says. So that's why what Mr. Dhankhar is saying attains a salience of its own. Okay, that's one point of view. Let me open this up further. Nikhil Jain is there with us.
Number two.
One second. Let's take it one point. This is a very important point you have made, sir. So let's have a quick discussion on it. 1 second, sir. Let me just bring in Deshratam Nigam, and let me also bring in Advocate Nikhil Jain. Nikhil Jain, where do you step in on this? Look, the point is, and I'll make it even more simpler for everybody. 1 second, Mr. Sinha. Let me just make it very simple for everybody. I'll just bring you in. 1 second. Mr. Jain, this is an important one. Look, it's an important issue. Let's not look at it from our partisan lens. A lot of people could tend to do that. You have had Mr. Sibal a few days ago. He's the one who's been most vocal in the criticism and one of the senior most lawyers of the Supreme Court today. He says that this is in fact an intrusion on the supremacy of the legislature and the Dhankhar criticism of the Supreme Court, etc. Now you have a situation when a few months ago he said the perception in public is the confidence we had in the judicial system seems to be on the decline. So when he says it's okay, when someone else points it out who happens to be actually an authority, also a lawyer and a vice president, then it becomes problematic. It impinges on the supremacy of the judiciary, etc. How does this work?
So Rahul, the difference in the two things is that one is talking about the integrity of the institution as it exists today and the people manning that institution. Other is the constitutional power and mandate of that institution. What the Vice President Dhankhar is criticizing right now is the constitutional mandate of the Supreme Court, and I completely agree with Mr. Lekhi that a lot of the things that the Vice President has said are plain wrong. This constitutional scheme of the country does provide for the Supreme Court and the High Courts to indulge into what we call as judicial review under their jurisdiction and other powers under the Constitution to keep a check on the executive. And who is the President? President is essentially the head of the executive at the union level, and governors are head of the executive at the state levels. it is perfectly within the power of the Supreme Court to go around and look into the actions of the president or governor, because whatever actions the union government takes, they are essentially in the name of the president. So even when the Supreme Court quashes any government policy, that is also essentially an action against the president. So for the Vice President of India, who himself has been a senior advocate in the Supreme Court, for him to come around and say that it is beyond the powers of the Supreme Court and the Supreme Court cannot order the president because the president is the highest dignitary, I think that's a very fallacious argument to make.
I'm not denying that. I'm not denying that, Mr. Jain. I think we're not understanding what I'm trying to say here. I think all organs of the state, all organs of the state have to be equally transparent, Deshratam Nigam. The point is that today there seems to be.
I complete my point.
One second, that there is autonomy from accountability for the judiciary. And this is what Mr. Dhankhar is getting at, that the judiciary cannot be seen to be above account. Yes, preserve its autonomy, but that doesn't mean that there should be no robust mechanism for judicial to question judicial misconduct, which seems to be the case in this, the way this judge matter has been handled. Then there is this contempt of court laws, which sort of predicate any offense which says scandalizing the court, which is open to, all sorts of interpretations and is being used as a shield to prevent criticism of the judiciary, etc. How do you make out?
Rahul, in fact, let me point out one thing. I think the lawyers in the court who were present missed one very important point. If you look at Nabam Rabia's case, which was a constitution bench case of 5 judges, where this issue of time frame had come, and court refrained from giving that time period. They said as soon as possible. They did not lay down the time period, and therefore it was judicial propriety required that this matter should have been referred to the 7 judges. Remember, not that the 2 judges should have decided this matter. It should have been referred. It's a judicial propriety required because Nabam Rabia case refrained from, stating the timeline.
Okay.
That was a 5 judges bench. Now, secondly, when you talk of collegium system, it was never a part of the structure of the constitution, and the Supreme Court says it becomes basic structure. Something which was not a part of the structure of the constitution, how can it become basic structure where the appointment was with the executive, with the consultation of the Chief Justice for the appointment of judges? Completely reverse the situation, and I think Mr. Lekhi would agree that it requires consideration, and NGAC was a good step in that direction. It was struck down. Now,
but struck down by whom? That's the point, Mr. Lekhi.
So
what do you do then? What do you do if the Supreme Court stands in judgment of a bill that has been passed that basically intrinsically impinges on its own interest? Then isn't there a conflict of interest? How do you resolve this issue?
Rahul, this needs a nuanced answer. Now, as a proposition undisputed, that we need a better system for appointment of judges. No question about that. Having said that, the question is, merely because the law has been passed by the legislature doesn't necessarily mean that it cannot be examined and the court cannot strike it down. We may have disagreements with the striking down, but nevertheless the striking down is something which the court is entitled to do. That being done, it is open to the legislature to bring a fresh legislation in any case, should it be required. My problem here is the manner in which the debate is being framed. That is my issue, because as far as these issues are concerned, the way in which the debate is being framed is that one institution is preeminent and it is in some way objecting to an assumption of authority by another institution, because implicit in what the Vice President is saying is that, see, you cannot approach the President and you yourself are not open to accountability. So when you deal with a situation, you can't have one which has implicit in it a conflict, because you have to deal with it in a manner which is coordinated and balances everything. So want of balance is what I am talking about.
Okay, want of balance. That's what I started by saying, that there has to be an equal balance, a fine balance between all the organs of the state. Are we at a point where that is not happening? One, perhaps, given the fact that the word autonomy is constantly associated with it. is beginning to think that that means that it is above account. That's the only question that we need to pose. Viewers, I'm leaving you with the thoughts of four eminent personalities here, but I also want to tell you that this is a democracy and a debate is healthy. We require more debate. The greater the amount of debate, the more the clarity. And therefore, you might have a view on Mr. Dhankhar. You might think he's overstepped, breached this, that, the other, out of line, etc., etc. But remember, there are others who have also accused the courts of judicial barbarism. In the same newspapers that are today pillorying Mr. Dhankhar, those people got away with a lot more, some would say, than Mr. Dhankhar. So even the criticism has to be free of partisan lens. It has to be independent of biases. Let's have an open debate. You may disagree. Put out a better argument. I leave it to this, viewers, but there is a problem. It needs to be addressed. I think everyone has addressed that. They've all accepted there is a problem. How we go about addressing it is the consequential thing. And it will have an impact over the next 25 years, which is the target for Viksit Bharat. I leave it to this, viewers. Viewers, as you know, there's been a running battle going on between the BJP and by extension the NDA and the DMK government in Tamil Nadu. Almost every day, there are some words exchanged on some topic or the other. All of this, of course, is in the run-up to the 2026 Assembly election, and that's really only 12 months away. And in the hurly-burly of Indian electoral politics, that's actually a very short time. But in this run-up, in this build-up, in this increasingly stressed relationship between the DMK and the BJP and by extension the NDA, there has been a lot happening in the background in Tamil Nadu. There's been a 360-degree churn in Tamil Nadu politics. The BJP has decided to abandon its solo run and join hands with the AIDMK. The Saffron Party's state-level mascot Annamalai, known for his confrontational style, some would say, has also passed on the state presidency to another colleague. The assembly election, as I said, is just about a year away, and the DMK's ability to project itself as the only defender of Tamil rights seems to have succeeded in deflecting attention away from its governance deficiencies. At least that's what the BJP is saying. Let's decode the political scene there with influential ideologue S. Gurumurthy, who also incidentally met with Union Home Minister Amit Shah just before the latter announced the BJP's tie-up with the DMK. Mr. Gurumurthy knows the state politics like the back of his hand. He also has a wider national perspective, and therefore he is perhaps the only authority that can comment also in a manner which is objective on this entire issue. So, Mr. Gurumurthy, thank you very much for joining us. You have been in the past, and we've had many conversations, been highly impressed by K. Annamalai. What do you make of Mr. Annamalai's exit from the political forefront in Tamil Nadu?
Yeah, I wouldn't say it is exit, because I have been very closely interacting with him. This is a decision which the BJP and Annamalai have together taken. It's not that it's a decision taken by the BJP or Annamalai. You know, in Tamil Nadu politics, Annamalai broke the ice for the BJP. And 2024 elections, which of course went against the N.D.A., that is the BJP and the ADMK put together, but it changed the mutual equation between the BJP and ADMK, because the ADMK vote share, that is the ADMK plus vote share, came to about 23 plus, and the BJP vote share, BJP plus vote share, came to 18 plus. This is a very major shift in Tamil Nadu politics. After 1989, when the Congress got 20% votes, the Congress votes had gone into the ADMK, which had become the pseudo-nationalist party after M.G. Ramachandran broke away from the DMK and called his party All India I.N.D.I.A. That is the first major move for de-Dravidianization and the attempt to decouple Tamil Nadu politics from national politics was stopped by M.G. Ramachandran. From that time onwards, because there was no charismatic leader in the Congress votes had gone into the ADMK hands. So that was how the DMK and ADMK polar politics arose. Now the BJP has partly restored it back to the national level understanding of politics among the electorate. Otherwise, they were not even aware of the national level implications of voting. This was possible because of Annamalai. And I have interacted with him very closely. It is not that Annamalai has been kept out. It's very wrong to say that. Annamalai is very much in the picture. But to make the alliance work, it is necessary that you make a perspective difference to the whole thing, and that is how BJP and Annamalai have together come to the conclusion that it is necessary to defeat
essentially, what you are saying, if I may, sir, is that this is a strategic sacrifice on his part and perhaps even the party's part. It's not some sort of course correction or some sort of punishment.
I wouldn't even call it a sacrifice, because he is probably the only state leader who, without occupying a position as minister or as chief minister, has made an impact at the national level. He has grown at the national level. So he can be very easily absorbed at the national level, for which also the BJP is now doing the organizational resetup. And so Annamalai will not be lacking in space. And he will be the face of the BJP campaign in Tamil Nadu, whether he is the president or not. Oh. In fact, even the present president of the BJP, who has succeeded him, has said that he will be the mascot of the party. So Annamalai is not being sacrificed. I mean, that's not the case. Another thing, the BJP is not repeating the state leaders a second time. So repeating Annamalai a second time may also mean that they are unfriendly to the ADMK. I think that the BJP has taken a very conscious and strategic decision, and Annamalai is part of the decision.
So without the post of the president of the party in Tamil Nadu, can Mr. Annamalai still exert authority in his usual assertive and somewhat confrontational but very, very confident style? Will he be able to do so, not just in the party, but obviously also project outwards towards the opposition?
You see, 80% of his confrontation, maybe even more, was against the DMK. That is going to continue. But his aggression against the ADMK will be toned down. Normally, this is an acceptable principle in politics that you will not be speaking against your own alliance partner. Even if Annamalai was the president, he would not be able to do it. And so it is not going to make any difference to Annamalai's grip on Tamil Nadu politics. To the extent that he has been opposing the DMK, he will be probably the principal voice against the DMK in the coming elections also.
Okay. So does the BJP's decision to now return to an alliance with the AIADMK reflect a pragmatic reading of the ground realities or a surrender of ambition? Many people are saying it's a surrender of ambition. They should have gone solo, built the party, taken the long route.
You see, the BJP, I know Tamil Nadu politics for the last 50 years. I mean, Cho Ramaswamy and me were probably the only two persons who were intensely studying Tamil Nadu politics. Tamil Nadu politics has been de-Dravidianizing. Ideologically, it has ceased to be Dravidian. Most people do not know it. In 1970, the society and Dravidian politics were one and the same. It was anti-Hindu, anti-Brahmin, anti-North, anti-God, anti-temples, anti-everything that Tamil Nadu stands for today. But the society has moved completely away. But thanks to M.G. Ramachandran breaking the back of the Dravidian movement, the society stands away from Dravidian politics. And the Dravidian politics is now surrendering to the Hindu political signals, symbols, rituals. So this is a churning that has taken place without any political intervention. This is Tamil Nadu culture reacting against the Dravidian imposition. So this is the time for any national party to get its hold in Tamil Nadu. The BJP has proven that it has the capacity to do it, potential to do it, ideas to do it, and also the person to do it. But the first thing is they have to remove the DMK, which is symbolically Dravidian. It is not ideologically Dravidian anymore. It's only the name. It is now smuggling Dravidianism under Tamil chauvinism. So the BJP has to now defeat the DMK, for which this alliance is needed. It is strategic move by the BJP. And look at it from ADMK's point of view. If ADMK is defeated in the next election, it will be a sunset party. For ADMK, it's a question of survival. BJP, it is a question of taking the fight to another level by defeating the DMK. A defeated DMK is much easier for the BJP to handle in 2029 elections than a DMK in power, for which the BJP can slow down its organic growth. And that is what it has done.
So you have long spoken, and you again reiterated this cultural nationalism aspect. Now, in a state like Tamil Nadu, where regional pride runs deep, how does an alliance with AIDMK further that ideological goal? You're saying right now the idea is to get the DMK out of the picture without, in a sense, symbolically upsetting the Dravidian equations. But long term, even though the BJP will be the junior partner of the AIADMK, how does it attain this goal if it's going to constantly be dependent on?
No, that again means you have to have a much deeper analysis or understanding of Tamil Nadu politics. You see, for a political party to sustain itself and grow, an ideological political party, it must have ideological grip or a charismatic leader when it compromises with ideology. When you are compromising the ideology, if you have a charismatic leader, then the compromise with ideology can be managed. That is what Karunanidhi did. He compromised and formed alliance with the Indira Congress in 1971 because charismatically he was seen as the Dravidian leader, articulate, competent, strategic, leadership. If you see both in ADMK and DMK, there is no such leadership. There is no charismatic leadership, and there is weakening of the ideology. That is why I say that a DMK is no more the same DMK as it was 50 years ago. But if it is in power, symbolically it has inherited the Dravidian separatism. And it's again and again it implies the separatist tendencies in various ways. ADMK has given up its separatism. It may speak for electoral purposes, it may speak anti-Hindi, it may speak anti-NEET, but it is more for perception. And there is actually nothing Dravidian in the sense of separatism left in the ADMK. So it's a much better combination for the BJP to work with.
Despite the anti-incumbency in undercurrents, and we know that there are strong ones, the DMK's political machine on the face of it looks robust. Is the DMK's aggressive play of identity politics perhaps a winning strategy? Have they taken that space? Let's put it that way.
No, actually this ideological aggression which they are showing is mostly a media product. This, even the aggression against NEET, nothing on the ground. This 3-language formula, nothing on the ground, because the media in Tamil Nadu has completely surrendered to the DMK. And the English media is ideologically against the NDA, that is the BJP. It suits the DMK. But on the ground, the situation is not that. The kind of aggressiveness which the DMK used to show, which was consumed by the electorate in the past, it's not going to happen. It is not happening. So the perception is different from the reality. My view is that in this election, the DMK will be on the back foot. It would not be able to perform what it did in 2021 and certainly not in 2024. Its vote share is actually coming down. And my view is that if the ADMK BJP alliance works, the DMK is in serious trouble.
Serious trouble. What is the one area where you would think the BJP sort of falls short just a little bit?
See, it is mostly because it is probably the perception that the Congress party created, that it does not sail with the regional aspirations, it does not sail with the idea of Tamil pride, Tamil culture. You know, I have myself seen in Tamil Nadu, even local Tamil leaders addressing meetings in English. When DMK leaders will be sweeping Tamil Nadu with their eloquent Tamil, and I mean, it was stage set for the Congress to eclipse because of its inability to understand. And Congress had a very great man, Kamaraja, the leader, and he was not an orator. His presence itself meant what he was. But after politics became demagogy, the Congress lost out. But where Modi made a difference, he began identifying himself with Tamil literature, Tamil language, Tamil culture, Tamil way of life, Tamil worship. So the kind of Modi go back and the kind of attitude that was there in 2019, even last year, the Modi get out. Stalin get out was 60% more than Modi get out. So the tables have turned. BJP has understood, because BJP is basically a cultural party. Because secularism actually rejected the culture of India. So it could not understand the cultural, the diversity of India was not understood by the Congress. The BJP understands the diversity, contrary to the perception that the BJP is against diversity. BJP is fully in know of what is diversity. Okay. And so it is able to align itself with the Tamil diverse aspirations, and Modi's role has been enormous in this.
There has been some crosstalk. The AIADMK frontman has been quoted as having said that we don't want the BJP. The BJP says no, that was misquote, misreading, disinformation, deliberate. He didn't say that. He said we'll be the senior partners. The BJP will obviously be there. Did you get a sense that there is dissonance?
You see, it is not dissonance. Actually, this all started with the 2024 electoral separation between the BJP and the ADMK. And afterwards, when the BJP did not get majority, possibly the ADMK leader, Edappadi, thought that the BJP will not be able to make inroads into Tamil Nadu in the way it was able to do it when it was having a majority power at the center, and Modi will not be that effective. This was his calculation. So immediately after the election, he announced that we are not going to ally with the BJP either in 2026 or even later. That was probably a reactionary statement to the BJP not being able to get majority. But after the BJP won in Haryana, there was a question whether the tide is turning for the BJP. Then Edappadi made 3 statements in the month November alone, that he will never ally with the BJP. 13th, 14th, 15th, 3 days he made the statement in the context of the Maharashtra elections. But in Maharashtra, when BJP won, afterwards this stopped. When the BJP won in Delhi, pressure began building up within the ADMK, because in the southern and Western Tamil Nadu, neither the BJP nor the ADMK can win without being with in alliance. So the ADMK has taken a practical decision.
I want to ask you, this is one fundamental question. In a landscape where language and identity tend to dominate, what is the one principle that BJP should not compromise on in Tamil Nadu?
You see, actually, the BJP's compromise can only be that ADMK and DMK seem to have agreement on certain issues. For example, the three-language formula and the NEET issue. These are the issues in which the BJP seems to be taking a different stand. Even the Congress seems to have given up its idea of a national party, and it is virtually the shadow of the DMK. But this is not actually isolation. Actually, the BJP's core strength is that today, these NEET or three-language issues is not a mass issue. If it were a mass issue, Tamil Nadu would have come to a grinding halt, particularly on the language issue. Nobody is bothered.
Look, the stage is set, and thank you, Mr. Gurumurthy, for speaking with us. I think the countdown has begun. Let's be very honest. That's why we've seen that interaction, and you can see those pictures on your screens. Right besides Mr. Gurumurthy, Amit Shah leading this tactical foray into Tamil Nadu. So clearly, the blocks are being put in place. And once the starting blocks, yes, sir.
I have a request.
Yeah.
You must all read Tamil Nadu more closely, study
completely
more
agree with you.
With the historical background of the paradigm shift that is taking place in Tamil Nadu. It is not being, because in Tamil Nadu, media is not very critical enough. The all India media can be and should be, according to me, because that is in the interest of Tamil Nadu and also nationalism in Tamil Nadu.
Well, wise words, as always, backed with a lot of experience, viewers. That's why we have Mr. Gurumurthy speaking to us. Thank you very much, Mr. Gurumurthy. Pleasure as always. Thank you.
Presented by Hello, Namaskar. This is First Post and you're watching Vantage with me, Palki Sharma.